Excellent. All right. So yes, as Ryan said, my name is Morgan Sheppy. I'm the attorney for the Child Advocate Program of Pierce County. And I'm here today to give you the legislative and case law update. We're kind of going 2020 and 2021 because we didn't really have a lot of time to chat in 2020. So just to give you a little bit of an idea what we're going to talk about specifically today. We're going to start with the legislative update, so talk about the statutes that were passed by our legislature in both 2020 and 2021. Going to talk a little bit, there were some Supreme Court personnel changes in 2020 specifically, so we're going to talk about those a little bit. And then I'm going to go through some of the appellate court decisions first that were issued in 2020, 2021. And then some of the Supreme Court cases that have been issued that handle how we deal with child advocacy in the state of Washington. So I'm open to questions at any time during the presentation. I'm going to ask Ryan to kind of help field those if anything pops up, but feel free to put things in the chat as well if you have any questions. I do have some time built in at the end to answer any other questions that you might have. All right. So we're going to start, like I said, with the legislative update. We really only have two cases or two pieces of legislation in 2020 that came out. That's, of course, because COVID kind of hijacked the legislative session and focused some things a little bit differently than what was pending. So the first bill that passed in 2020 was called the Family Connections Program. And this was a development of two pilot programs, one on the eastern side of the state, one on the western side of the state. And the objectives for those programs was to encourage in-person meetings between biological parents and foster parents when it's safe to do so and when foster parents agree to do so. So that was the plan. It was signed into law by Governor Inslee back on March 18th, but the governor vetoed the funding for the program. And then also COVID happened. So in-person meetings were not high on the list of things that were feasible. There have been some programs that have come up. I know that there's a session, I think on Friday, with Katie Byron, who actually came and spoke with our group a couple of weeks ago, but they are working to kind of foster this program. So finding cases where biological parents and foster parents, when it's safe and everyone agrees that they can meet and help provide the best care possible for the children, exchange information and get really connected with each other to help care for this child. All right, the second bill that passed out of 2020 actually came out of a court case, which we're going to talk about a little bit later on, but it is the State versus Wrigley case. So this was a change in the language for the mandatory reporting laws, so reporting child abuse and neglect. So you can see there the words that are in quotes is exactly the change that was made. So originally the statute had said the department has the law enforcement or the department has a duty to investigate when there is a report concerning the possible occurrence of child abuse or neglect. And that language is actually changed to say crossing out concerning the possible occurrence of and just alleging that abuse or neglect has occurred. So we'll talk a little bit more about why that came about when we talk about the court case, but this just has to do with mandatory reporting laws. It also amended the law so that anyone in good faith who makes a CPS referral, makes a mandatory report about child abuse or neglect, is immune from any civil or criminal liability. So that was added into the statute last year, 2020. All right, so then we're going to talk about the legislation that passed for 2021. We have a couple of big ones, some that have already been put into place, some that are going to be put into place, and then some that are in some sort of process thereof. So the first one we're going to talk about is a big one. It's the Attorneys for Kids bill that has been floating around for several years now, finally passed. So I have a couple of slides talking about this and what this is going to look like. So essentially, what this bill does, what the statute does, is it provides state paid attorneys through the Office of Civil Legal Aid for all children in dependency cases ages 8 and older. So this is going to be a kind of a slow rollout. There's going to be 6 waves, and it starts next summer. So starting in July of 2022. And then the goal is to have this all implemented by January of 2027. So the rollout, there's going to be, at a minimum, this is going to be in 3 counties by July of 2022. And then January of 2023, 8 counties total, and then 15, 20, 30, and then plan is by January of 2027, there's going to be statewide implementation fully. There have been some lists kind of floating around about what counties are going to be in what order. I found out today that's not a confirmed list. That's most likely, but it's totally not confirmed. Some counties, I think it was Grant and Lewis, did a pilot program with this over the last couple of years. So they're probably going to be in that first wave because they're already doing it. But they were kind of the pilot and the experimental counties for us in testing this idea of appointing attorneys for all kids. So the priority in picking which counties they're going to roll this out in first, that's the language that's in that bottom bullet there. So they're prioritizing counties that do not currently have a practice of appointing attorneys for children, or have a significant prevalence of racial disproportionality or disparities in the number of dependent children as compared to the population in general. So they are going to be looking at the data on that, and that's how they're going to sort out which counties are going to go first. So essentially, this is kind of the nuts and bolts of what this actually looks like. The statute provides for the right to counsel for all children between the ages of 8 and 17 who are either alleged to be dependent or adjudicated to be dependent. That's all the kids in our system. So the attorney for the child is going to be assigned at or before the initial shelter care hearing, so at the beginning of the case. If there are children ages 8 through 17 who are already in existing dependencies who don't have attorneys, they will be appointed one when their county comes through on the slow rollout. So for any new cases, that attorney is going to be assigned at the beginning. And then for any kids in existing dependencies who don't have an attorney, they're going to be assigned one when their county comes up on the list. The second part of it is the right to counsel for all children ages 0 to 17 when a termination petition is filed. So if there's a child who's 0 to 7 who doesn't have an attorney in the dependency, once the termination is filed, they will be assigned an attorney. If an attorney if a child is 8 to 17 and has an attorney in the dependency, that attorney will also be assigned to the termination. So there's going to be some continuity there. They're going to have the same attorney in the dependency that they have in the termination case. Okay, so like I said, that's going to be a kind of slow rollout. There are some counties who are going to go first and kind of see how that works. I am, shameless plug, next week I'm going to be speaking with Bailey Zedak, who is counsel for the Office of Civil Legal Aid, and part of our presentation is going to talk a little bit more in depth about this and how we can work better with children's attorneys to advocate for what they're advocating for best, or for what's in the child's expressed wishes. We're advocating for best interests and how we can work together to get the best outcomes for children. So she'll have a little bit more details about kind of what they're looking at in terms of training and how they're going to be rolling out this Attorneys for Kids idea across the state. All right, so the next bill that passed in 2021 is 1194, and this is regarding parent-child visitation. So this one is actually already in place. It passed at the end of the legislative session and pretty much went right into effect over the summer. So if your county is a little bit like ours, we're kind of scrambling to figure out how to make this all work, but and I'll let you know what our county is doing specifically. But basically, it changed a lot of things about the guidelines around children visiting with their parents, doing family time with their parents and their siblings for that matter. So the first piece of this is that the first visit between a parent and child has to occur within 72 hours of the child being delivered to DCYF custody, unless the court finds that extraordinary circumstances require a delay. Of course, they haven't defined what extraordinary circumstances are. So generally speaking, a parent and child need to visit within the first 72 hours that a child is brought into care. If that first visit is in person, it has to be supervised. That's what the statute says. And of course, a lot of times a referral hasn't gone in at that point, it hasn't been picked up. So a lot of times that first supervised visit is going to have to be managed by a social worker through the department, because they're going to be ones that are first involved in that case. Throughout the course of the case, visitation can only be limited where necessary to ensure a child's safety, health, or welfare. Visitation cannot be limited based on a parent's failure to comply with services. That's not new. It's just highlighted a little bit differently in this bill or in this statute. Generally speaking, visits after that first visit, visits are to be unsupervised unless the presence or threat of danger to the child requires the constant presence of an adult to ensure the safety of the child. So what the statute is kind of doing is it's changing around the presumption of what visitation looks like. So that first visit, if it's in person, supervised. After that, the presumption is that visits are going to be unsupervised unless there's a specific articulable threat of danger to the child that requires another adult to be there constantly to secure the safety for that child. And so this continuing discussing that. So at each hearing throughout the dependency after that initial shelter care, this includes at a 30-day shelter care hearing, which we've started doing in Pierce County. But throughout the dependency, the presumption reverts back to all visits being unsupervised, not monitored, not supervised, unsupervised, unless a party provides evidence to the court that removing the supervision or monitoring would create a risk to the child's safety. So what happens in Pierce County is prior to specifically that 30-day shelter care hearing, and otherwise it's in the court report, but the social worker puts together a safety assessment and kind of details, here's what's going on with the visits, here's the reasons the children came into care, here's the recommendation for if we want anything besides unsupervised visits. So if we want monitored or supervised visits, here's the specific safety risks to the child. And then the court, at that hearing, the court has to make a decision saying, yes, the department has demonstrated that we need another adult there to protect the child. DCYF's failure to provide visits may result in the court finding that DCYF has not made reasonable efforts. So if the department isn't providing visitation in the way that they're supposed to, the court may, we got that checkbox, the court may say, hey, department, you're not making reasonable efforts to get family time for this family. That's a possibility. And this is one that we come across quite frequently, but the lack of visitation providers will not excuse this failure. So if the department does not, if they say, hey, no one's picked up this referral, we can't provide visitation of this family, that's not enough. The department has to find a way to provide family time for a family. And again, that family time, unless there's a specific articulable threat about the safety, that visit needs to be unsupervised. I think I did see a question in the chat that said, how is safety assessed if no one can observe the visit? So we will have some, the visits can be observed. It's difficult, obviously, at the beginning, because sometimes we're not assigned and we don't have all the pieces in place, but visits can be observed. And if there's something, if visits are going unsupervised and observed are two different things. So we could be observing an unsupervised visit. And if we were, as an advocate, saw something that brought some concern, obviously we'd talk to our program coordinator, possibly talk to the department, and there could be, a change requested for visitation at the court to say, hey, we observed, mom dragged the kid, across the street when they were going to the park and, in traffic or something to that effect. And we could say there's a risk to safety. We need to go supervise for a little bit. That's entirely possible. But again, whoever wants supervised visits, whether that's us or the department, or I suppose even a parent could ask for supervised visits, but they would need to bring that to the court, make us showing that there's a specific safety risk that we need to have another adult there to ensure the child's safety at visits. And again, this is reviewed at every single hearing throughout the life of the case. Okay, so next is House Bill. I'm taking a look here, a couple of chats. Should we observe visits more often, more regularly? Otherwise, parents' interactions with the child won't be detected. I think it's always good to observe visits if you can. Of course, observing visits is only one way to collect information. There's lots of other ways for you to collect information that may give you some information about how the parent is interacting, and that may give you some ideas about child safety or some things to follow up on about child safety. If visitation reviewed every day or at every hearing, it's at every single hearing. Usually there's supposed to be a 30-day hearing, or at least we do in Pierce County, there's a 30-day hearing after the case starts. And so we review visitation then, but then it's at every hearing after that. Of course, if there's if there's a safety concern at, say, we do reviews every 6 months. Say there's a safety concern that pops up at 4 months, you can always talk to your program about potentially bringing a motion and bringing it to the court before a review to talk about, hey, maybe we need to change visitation in the interim, and then it would be reviewed again at the next review. Part of visitation is in the most natural setting. Yes, the goal is to make visitation in as natural a setting, I don't want to say as normal of a family setting as can be, but how would this family interact if we weren't involved with them? Would a child resisting visitation be a reason to ask for monitoring? It could, it depends. You may want to, if the child has a specific reason for it, that may be something that if they've got an attorney, that their attorney could work with, because that's an expressed interest thing, particularly if it's different than what we feel is in the child's best interests. So, if we were, on track for a return home soon, and we know that we need to have this ongoing visitation, and we thought it was in the child's best interest to continue visiting with the parent as we're working on a transition home, but the child's resisting, that may be a case where the child's attorney would step in and advocate for what the child wants, because it would be different than what we would be asking for as in the child's best interest. So it could be a reason, but I don't know. It's going to depend on your court whether that rises to the level of it being an actual safety risk to the child. Yeah, advocate for the kid to go to therapy. Yep, that's a good idea. Have the therapist work with the child to maybe find out, is there a specific safety threat? Is there, what's the reason the child is resisting? And could that rise to the level of being a specific threat that needs monitoring or supervision? Okay, next up, we're going to go to House Bill 1227, which is Keeping Families Together. This is not in effect until July of 2023. So we have a little bit of time to figure out how this is going to work, because it's, so it's going to change a couple of things on how the department can essentially bring kids into care. So we've got a little bit of time to figure out what the department's going to do with this and how they're going to interpret things. But this is going to, I have a hunch that this is going to have a big impact on how our cases are brought into the system. So the first thing here is it's going to change some things in the dependency petition. A couple of things with regards to IQA, and this is a result of some cases that we're going to talk about in a little bit, but it adds basically the reason to know that a child may be an Indian child, or that a child may be an Indian child. So it's a lesser standard. So if we'll talk about this, but if anyone brings up the possibility that this child might be Indian, then the court has to treat it as an IQA case unless the tribe demonstrates otherwise. So it has to include that specific language in the dependency petition itself. It should include the names and addresses of the caregivers if known. I saw a question in the chat that said that might be is that a safety concern? It might be. If that's the case, we have some cases where child placed with a relative and there's been existing animosity between the parents and that relative. It may be that that address is kept confidential for the purposes of this, knowing that there is a history there. But otherwise, it should include the name and the address of the caregivers. Should be listed in the dependency petition. It has to include, the dependency petition must include a clear and specific statement as to the harm that will occur if the child remains in the care of the parent or caregiver, and the facts that support that conclusion. So those are the changes specifically for just the initial dependency petition filing. So some changes to both hospital holds and law enforcement holds. This brings them both to the same standard. So the burden of proof for a hospital hold is now probable cause that detaining the child is necessary to prevent imminent physical harm to the child due to abuse or neglect, and that the child would be seriously injured or could not be taken into custody if it were necessary to first obtain a court order. So previously it was reasonable cause. Now it's probable cause. So it's a little bit stricter of a standard. And the big thing that we're going to be talking about with this particular statute is that idea of imminent physical harm to the child. A hospital hold can only last for 72 hours. CPS can detain the child for up to 72 hours till the court assumes custody of the child. There's a question of whether those two time frames run at the same time, if it's one set of 72 hours or if it's consecutive 72 hours and then 72 hours. That's not entirely clear. So we're still waiting for some clarification on that. For law enforcement holds, it's again, the burden of proof has changed. So it's now probable cause that detaining the child is necessary to prevent, again, imminent physical harm to the child due to abuse or neglect. And there's insufficient time to serve the parents with a dependency petition and hold a hearing prior to removal. So basically it's saying that the risk is so great to these children that we need to have law enforcement involved and remove the children before we have a court hearing to determine if it's appropriate to remove the children. Law enforcement pickups, the petition for a law enforcement pickup has to include corroborating evidence, so more than just allegations. That establishes that removal is necessary to prevent imminent physical harm, and that removal prior to a 72 hours hearing is necessary to prevent imminent physical harm. So the question is, what differentiates reasonable cause and probable cause? It's a good question. Probable cause is a little bit higher of a standard. So a court ultimately has to determine if the department has proven that. So reasonable cause is, if you think of it kind of trying to describe it, we spent an entire class in law school on this kind of thing. So probable cause is it's a little more of, it's a criminal standard, but it's still not a criminal case. So if you think about it that way, it's hard to prove someone committed a crime and to put them in jail just because of all the constitutional issues and all that kind of stuff. So it's a higher standard that they have to demonstrate. So it typically requires more evidence, more corroborating evidence. It's going to be a little bit tougher for the department to demonstrate. They're going to have to do a little bit more work to not just throw a bunch of allegations in there, but to actually kind of demonstrate some, cross-referencing and some corroboration of the information that's in there. Okay, so a couple of changes to shelter care hearings. So shelter care hearings may occur before a child is removed from the home. So that's possible. A court must find, and then this is an exact quote from the statute. This is, I think, where a lot of the work is going to have to be done. So the court has to find that removal of the child is necessary to prevent imminent physical harm due to child abuse or neglect, including that which results from sexual abuse, sexual exploitation, or a pattern of severe neglect. And it is contrary to the welfare of the child to be returned home, and any imminent physical harm outweighs the harm that the child will experience as a result of removal. So the court has to find all three of those things in order to have a child placed in out-of-home care. So again, there has to be, we have removals necessary to prevent that imminent physical harm. It's contrary to the welfare of the child to be returned home. And the imminent physical harm outweighs any risk or trauma that the child will experience from being removed from the home. So this is going to be it's going to be interesting to see how courts interpret this, but it could possibly be a pretty high standard for the department to have to meet in order to have children removed from their parents and brought into out-of-home care. So once the court finds those three things that were on the previous slide and we talked about it, the court shall consider whether preventative services could have avoided removal. And if the parents agree to participate in those services, the court shall place the child with the parent. So depending on what the specific issues are in the case, maybe it's drug abuse. So what kind of services could be put in home to kind of work with the parents on mitigating those particular issues. And if the parent agrees to do that, we're not at dependency, of course, so the parents would have to agree to do it voluntarily. The statute says the court shall place the child with the parent in home. So evidence that the department presents must show a causal relationship between the conditions in the home and that imminent physical harm to the child. And so the statute actually lists a number of things that do not by themselves constitute imminent physical harm to a child. And these are, I mean, this would be kind of a summary of a dependency case would be this list. So poverty, the age of the parent, single parenthood, substance use, crowded or inadequate housing, mental illness, prenatal drug or alcohol exposure, disability or special needs of a parent or child, or non-conforming social behavior. None of these by themselves constitutes imminent physical harm to a child. So it has to be some combination of these with other things. But this is not, if we just say, hey, we have a parent with mental illness, so we need to remove the child, the statute is saying that's not by itself, that's not enough. Yeah, so Adrian asked, so maybe we will see more in-home dependencies. That's entirely possible. Dependencies with in-home services in place. That it remains to be seen how the department's going to handle this, and then how the courts are going to handle it. That's a very likely possibility, is that the court will find that there's not enough necessarily to remove a child, but that we could put services in the home to help mitigate some of those safety threats. All right, so we're still on this statute. It's got a lot to it. And like I said, it's going to be interesting to see how they put this together. So the statute does also address placement of children who are brought into dependencies. So relatives and suitable others are still preferred if a child can't go home. So if there is a reason the court does find that, hey, to prevent imminent physical harm, we do need to remove that child, we still have a preference for relatives and suitable others. Foster care can only be used if there's no suitable relative or caregiver capable of ensuring the basic safety of the child, or if such placement would hinder reunification. So if we have a grandmother who she can care for the child, but she does not want that kid to go home with the parents, that may be an issue where the placement is hindering reunification, and the court may decide that she's not an appropriate placement for the child. So particularly at that shelter care hearing, but probably at every hearing afterwards, the court has to ask everyone who's there if there are any relatives or suitable others who are willing to care for the child. Lack of background check, uncertainty about adoption, the relative's disbelief about a parent's inability to care for a child as long as they can abide by the parent-child contact, or whether the relative could meet the requirements of licensed foster homes are not reasons to deny placement. So if we have a relative who doesn't have a background check and the department says, hey, we can't place the kid there because we don't have a background check, that's not a reason to deny placement under the statute. One thing I would note, this is something we come across quite a bit, is the lack of a background check. It doesn't say a failed background check is a reason to deny placement. So that may be something that gets, further litigated or gets some more clarification. But basically just a lack of a background check, if they're not sure, if the placement's not sure if they're a long-term resource, they don't believe that, mom abused the child, that's not a reason to deny placement with that relative. They're given a great weight to the parent's preference. So where does the parent want the child to go? That's something the court definitely needs to consider. If a relative is found later, so if it's not, at the beginning of the case, but some period later on, attachment to current foster parents is not a factor in placement with a relative. So sometimes, for whatever reason, we have relatives who aren't found until, 18 months, 2 years down the road, and they want to be a placement. And then we have that setup where it's the foster parents versus the relatives. And a lot of times we have the argument is made that there's a great attachment. This is the only home, the foster home is the only home the child has known. But now that's something that the court cannot consider. So if a relative comes forward later, we thank the foster parents for the phenomenal care that they've provided to the child over the past 2 years. But that's not a reason to keep the child with the foster placement as opposed to moving them to an identified relative who can care for the child. Oh, we still have more. All right. So if the court orders foster care, DCYF has to report about the location of the proposed foster placement. Not really defined beyond that. My guess would be that it includes, at least the county that the foster home is in, if not a little bit more narrowly tailored. I would think in Pierce County, it may be, they're in a foster home in Tacoma, or they're in a foster home in Puyallup or something. It may be city, it may be zip code. We don't really know exactly how they're going to more narrowly define it. So the court also has to ask some questions about this foster home. Whether the proposed foster home is the least restrictive environment for that child. They have to ask questions about if the child can stay in the same school that they're in, or what can we do to ensure educational stability for that child. If the siblings are going to be placed together, and if not, what sibling visitation could be arranged to promote the well-being for the child. If the location of the foster placement will impede parent-child visitation. So if we have, for example, if we have a parent who lives in Federal Way, they don't have transportation besides the bus, and the child's placed in a foster home in Bothell. Is that going to impede visitation between the parent and the child to travel cross county like that? So these are questions that the court needs to ask in determining the best foster placement for the child. And the court can order DCYF to find a less restrictive placement if it finds that the placement's not the least restrictive environment, can order DCYF to put the child closer to a parent, home, or school, to place the child with siblings, and to take other action to, quote, ensure the child's health, safety, and well-being. So that's kind of a blank check to order DCYF to do what it needs to do to make sure that they're caring for the child specifically. I see a question in there: is trauma to the child by placement change a reason not to place with a relative? That's not specifically discussed in the statute. I would imagine that's going to be the argument that's going to be made about, moving children from, if they've been in a long-term foster home for quite some time. Maybe we're not talking specifically about attachment to the foster parent, but about the trauma of moving a child after being in one place for so long. So it's going to be interesting to see what kind of arguments are going to be made. I would imagine that's going to be a point that's brought up about, the trauma of moving a child from a long-term placement. So what if no other placement is available? So again, the preferences for relatives or suitable others. If no other placement is available, then we're looking at foster care. And again, the court has to ask some questions of DCYF to make sure that they are finding a foster home that is the least restrictive environment. And ultimately, it's preferred that it's a placement that's close to where the child's home is, and whether that home is their parents or their school. They seemingly want to keep the child in that geographic area to keep those connections. If no other placement is available, we'll have to see what the courts do. My guess would be that they're going to order the department to continue to find a foster home that meets some of these criteria. But as you all know, we have a real lack of foster homes. We need more foster parents, and we have a hard time finding foster homes for kids now. So this is really going to have DCYF have to do a lot of work in terms of finding homes that are closer to where the kids are from, to where they can have some educational continuity. They can continue to foster sibling relationships if they aren't placed together, and they can continue that family time, that parent-child visitation time, and that we're not placing kids so far reaching that it ultimately will be hindering their reunification. Okay, so that's the big one. Like I said, that one comes about in July 2023. So we have a little bit of time to figure that, well, DCYF has a little bit of time to figure that out. And we'll definitely see kind of what happens with that. A couple of other quick ones that passed at the end of the year. Hang on, I see a question here. How much weight will be given to the child's preference of where they are placed? For example, moving from a long-term foster placement to a recently found relative. The statute doesn't say anything specifically about the child's preference. It says it has to give weight to the parent's preference. Of course, now at this point, some of these kids will be having attorneys. So if the child has a specific preference of where they want to be placed, that's where their attorney is really going to come in. If the child has an express wish about where they want to be versus, what our argument would be as to what's in their best interest. So the statute isn't specific about the weight for the child's preference, but I would imagine it's something that the court will be considering especially if the child has an attorney who can advocate for that specifically. And also, this is a good point where, that preference really is for relatives and for fictive kin, suitable others. So this is a great opportunity for us to jump in at the beginning of a case and really kind of help, talking to the families and finding out who else could be a resource for them. Really help, kind of flesh out if at the beginning of a case, talk to the families, get more people as possibilities for this child. So then we don't have that issue where they're in a foster home for 3 years and then we find a family member that we want to move them to and have to tackle that trauma associated with that as well. So this is a good place for us to step in and do a little bit more work up front, because that's going to pay off in the long run and helping kind of mitigate some of that trauma for the child. Okay, so like I said, a couple of quick ones here kind of towards the end. Senate Bill 5184, school building foster care contact. So school districts now are required to have a point of contact for all dependent children, but now also each school building, so each physical building also has to have a point of contact for dependent children. So that would likely be somebody that you may talk to as part of your work initially, so that you'll have a contact at the school to kind of coordinate your work with the child at that school. 5151 is a child-specific foster care license for relatives. So this is part of a bigger bill, but our section we're kind of focused on is a child-specific foster care license for a relative to become a foster parent for a specific child. And it basically helps them so they can get federal foster care payments while the child is in their care. So rather than getting a general foster care license, they can have one for this specific child. That'll help them get some funding to help keep that care for that child in their home. Okay, so that's kind of the quick rundown of the legislative stuff that has happened over the last year and a half. Again, the big ones are the attorneys for kids, the parent-child visitation changes, which is in effect now, and then that bill about kind of the upfront when DCYF can remove a child from a home. And again, it'll be interesting to see what that looks like when it goes into effect in July of 2023. So two quick Supreme Court personnel changes. These both happened last year, so in 2020, but I just wanted to highlight them for you. So Justice Montoya Lewis was sworn in January. She is our keynote speaker, closing next Friday. I just saw her speak at I'm a part of a mother's attorney group, and she just spoke to us last week, and it was phenomenal. So if you get a chance to listen to that, please mark it on your calendar. But she was sworn in January of 2020. She was previously a judge up in Whatcom County, up in Bellingham for their Superior Court, also a judge for the Lummi Nation, the Nooksack Indian Tribe, and the Upper Skagit Indian Tribe. She has extensive work in child welfare and the juvenile justice system. When we get into talking about the some of the Supreme Court cases that have come down, she's written many of the opinions that have to do with juvenile justice because she gets it. She is an enrolled member of the Pueblo of Isleta tribe and a descendant of the Laguna Indian tribe in New Mexico. So I think she was the second Native American Supreme Court justice across the country, if I remember correctly. We also have another new justice, Justice Whitener. She was sworn in April of 2020. She was previously with the Pierce County Superior Court and the Board of Industrial Insurance Appeals. Her focus has been a lot in diversity, inclusion, and equity. She's an immigrant. She's from Trinidad. Part of the LGBTQ community and part of the disabled community. So she was sworn in April of 2020. So they've both been on the bench now for over a year, doing a lot of work. And like I said, a lot of the opinions that you'll see are coming from our newer justices with a lot of the social justice work that's coming through. All right, so quick reminder, we're now going to move into our case law section. So quick reminder, Washington appellate courts, we have 3 courts of appeal and then 1 state Supreme Court. So our courts of appeal, if a case was appealed out of your Superior Court system, it would go to one of these 3 divisions. Division 1 is basically King County North. Division 2 is Pierce County South and West. And then Division 3 is everybody over there. All of you guys over in Eastern Washington, you're Division 3. So if you were to appeal a case out of the Superior Court, it would go to your geographic appellate division. And then any cases that are appealed out of the appellate courts would go up to the state Supreme Court, which oversees all of the state of Washington. All right, so I'm going to go through the appellate courts first. I've divided them up by division. One thing that's kind of funny is, so a case that comes out of Division 1, which again is Seattle North, is not necessarily binding on Division 2, which is Pierce County South. However, the courts are pretty much consistent in everything, and I could argue in Pierce County, I could argue a Division 1 case as precedent over whatever we're doing in Pierce County. So it is important to kind of know what's going on in all of the different divisions. So the first one we're going to talk about is SMM. This came out in February of 2020 out of Division 1. So absent a finding of good cause, the court has to appoint a guardian ad litem. The statute, of course, says that a guardian ad litem has to be assigned, although if the child has an attorney, that fulfills the requirement as well. But the decision also said that general designation of a CASA program that does not result in any actual representation of a child's interests does not meet the statute. So you actually have to name a person, or if you designate a program, you have to make sure that there is actually representation of the child's best interest with that program. EJM came out in February of 2020 as well. I'm not going to go into it here because it was ultimately reversed by the Supreme Court, so I don't want to confuse you. We'll talk about it when we talk about the Supreme Court section of what actually the law is now regarding that. Okay, ANG came out in March of 2020. I think this was out of Whatcom County, but a parent's due process rights were violated when the judge failed to recuse himself from the termination trial when he had been the AAG seeking termination of the parent's rights in prior dependencies. So what happened was the judge had been an AAG before and then came on the bench. When this judge was an AAG, he had prosecuted the termination of mom's rights to her other children. And then when this case happened, the termination started, the judge realized it. He actually had a conversation with the attorneys, but not with the parent with regards to the conflict of interest, and went ahead and did the termination trial. Mom appealed, and the court said that was incorrect, that the conflict actually had to be raised with the parent directly. So that parent would have had the opportunity to ask for a different judge to hear the case. All right, still Division 1. Division 1 seems to issue the most decisions with regards to dependency. Not sure why that is, but that's where we are. So, okay, so WWS, the court lacked authority to order DCYF to assign a new social worker. So the parent can't just come to court and say, hey, court, I want you to assign a new social worker. Court can't order that. The court in this case also ordered a UA, even though there was no evidence that drugs were an issue in the case. And so the court found that that was incorrect, that there needed to be some reliable evidence in the record to support that a substance abuse issue existed to order a UA. And then the court found that a guardian ad litem has party-like rights in Superior Court and can appeal to seek to reinforce those rights throughout a hearing. Okay, recent case from June of 2021, evidence of sibling relations may be relevant in a termination case, but those sibling relationships are more properly addressed during the dependency itself, placement issues, and adoption issues. So in this case, the sibling relationships were talked about a little bit in the termination, but not a lot. And the court found that that was okay, that really the termination is about the rights of a parent and child. It's not so much about the sibling relationships. And there's these other places where sibling relationships should be considered, which is the dependency, placement, visitation as well, and adoption. JC came out in July, very timely for our unprecedented times. Specific telephonic and video conference protocols and procedures don't necessarily deprive a parent of an opportunity to be heard in a termination trial. So this was a case out of Skagit County, but the court was holding a Zoom termination trial, and there were some procedures that they put into place to help try and protect the parents' rights in terms of allowing breakout rooms, allowing the attorney and the client to consult with each other before questioning witnesses and things like that. The parent actually, I think, also had an opportunity to actually go into court if he wanted to. And so the court basically looked at the policies and procedures that were in place and said that this didn't necessarily just deprive the parent of the opportunity to participate. All right, Division 2. So this is again Tacoma South and West. A couple of cases. An IQA case, but basically IQA and WICWA require active efforts to provide services to prevent the breakup of a Native American family. Active efforts means more than just making referrals. We have a couple of Supreme Court cases we'll talk about in a second that really kind of hit this home. But the court should enter a finding whether active efforts under IQA would have prevented termination or whether it would have been futile. So again, this was a case where simply the department just didn't make active efforts for an IQA family. And the court found that that wasn't appropriate. TP, this is a case out of Pierce County, but the RCW requires the shelter care hearing to be done within 72 hours of a child's removal. A shelter care hearing can be continued only when a parent makes the request for continuance. So it's not a parent's attorney makes the request for continuance, it's the parent. So we have a lot of times we'll have an attorney say, hey, I can't do a contested shelter care today because of my schedule. That's not enough. The parent has to actually say, I would like a continuance to get witnesses or documents or whatever. But it has to be the parent that requests the continuance, not just the attorney. And then there's one case out of Division 3, which is kind of tangentially related to what we do, but a juvenile court has to allow a person who's pursuing a de facto parentage action to be a part of the dependency if their statement in support of intervention or being involved in the dependency presents a case that they are a de facto parent. So de facto parentage is a whole other can of worms, but it's a whole other law that if you are essentially acting in a parental capacity for a certain period of time, you have a relationship with the child, the court can find that you are a de facto parent. And this case basically says that if that has been demonstrated, then that de facto parent could become a part of the dependency and what would follow offering of services, all of that kind of thing. So that came out of Division 3 in August. Okay, now we're going to talk about the big ones, which are the Supreme Court decisions that have come out over the past year and a half. So this is one I talked about at the very, very beginning. Because again, the language was changed in the mandatory reporting requirements. So this case ultimately says a report predicting future abuse without evidence of current or past conduct of abuse or neglect does not invoke the duty to investigate by law enforcement or DCYF under the statute. And then again, Senate Bill 6423 was a direct result of this decision. So previously, the statute had kind of been interpreted where if a mandatory reporter said, hey, I think abuse is going to happen in this family, that would trigger DCYF and law enforcement to do some investigation. And so the language was changed that said, hey, unless there's evidence that this abuse is currently happening or there's a past history of this abuse happening, otherwise that duty doesn't get triggered. So DCYF, at the time it was DSHS, was sued, and there was a large they were sued civilly, and there was a large amount of money that was awarded against them because there had been this question of what did DCYF know in terms of the past conduct or history versus, I think it was a parent who said, if you place with this dad, the child will be dead in 6 months or something to that effect. And there was this question of whether that actually made DCYF have a duty to investigate. So the language was changed in the statute as a direct result of this case, basically requiring that there needs to be past evidence or evidence of current or past abuse or neglect in order to trigger that duty to investigate. Okay, so this is a Parental Rights to DH. It was a case that came out in June of 2020. I'm actually kind of surprised that this one was reported because this was a very fact-specific case. But it was a case where there was a parent who had rights terminated. And there was some question of course, it's always that one factor of whether the department offered all reasonable and necessary services to correct the parental deficiencies. And so in this case, again, the court reiterated the RCW that DCYF has to offer and provide all ordered and necessary services reasonably available and capable of correcting the identified parental deficiencies in the foreseeable future. And so in this case, the court found for DCYF and said that the record supported that DCYF identified the specific needs for mom and provided services tailored to those needs. So again, this was really a fact-specific case, but the court just basically, reiterated the statute saying that DCYF needs to identify parental deficiencies and provide services accordingly. Okay. MB. So this was another case that kind of has to do with alternative methods of termination trials. So in this particular case, this was the termination trial itself happened before all of the COVID stuff, but the parent was actually incarcerated at the time of the termination trial. So there were attempts made coordinating with DOC to have him present at the trial, but ultimately he was only on the phone for part of a hearing on the last day. So there were attempts to get him coordinated, but wasn't able to get him there the whole time that he needed. And the Supreme Court found that this was a problem. So termination trials must use fundamentally fair procedures that satisfy due process. Again, if we're talking about terminations, we're talking about due process of law. Parents have a fundamental right to parent their children, and so we have to follow some pretty strict protocols to make sure that their rights are protected. So the court stopped short of saying that an incarcerated parent has to be in person for a termination trial, but they indicated there were problems with the parent appearing by telephone when the other witnesses for the state were in person. Primarily, that has to do with the court's ability to assess credibility of witnesses. It's obviously a lot easier for the court to assess credibility of an in-person witness than somebody over the telephone. So the court found that the parent has to have the opportunity to actively consult with his or her attorney during the trial. And this is to point out inconsistencies in the state's case, to give their attorney information to counter the state's presentation. So say, the state has a witness who's testifying and they give some information that the parent thinks is wrong. The parent has to have the opportunity to let their attorney know that, so then their attorney can bring that up on cross-examination. So the court found some workarounds. They, like I said, they were stopped short of saying, a parent has to be in person. But there are workarounds when a parent can't be there in person. And so the ideas that they kind of came up with is to do breaks between witnesses for the attorney to consult with a client. So that may be, the state finishes calling its social worker, and then they take a break for the attorney to consult with the client to kind of go over some ideas for cross-examination. The other idea was for the client to review some of the transcripts. So, the court does transcripts either through a court reporter or a recording system, to have the client be able to review those transcripts before cross-examination, to give their attorney some ideas of things to ask on cross-examination or things like that. So I think ultimately the preference is for in-person to preserve due process rights, but there are some ways that we can work around that if it's not possible for a parent to be there, whether that's because they're incarcerated or COVID issues, that kind of thing. So I know in our system in Pierce County, for example, we're doing some trials by Zoom, some termination trials by Zoom. And so we allow, after witnesses, we allow breakout rooms for the attorneys to go with their clients into breakout rooms to talk, to discuss anything that they need to, and then they come back and then the attorney can do the cross-examination based on the information from their client specifically. So again, it doesn't necessarily say that a parent has to be there in person, but there has to be a mechanism for them to actively participate with their attorney during trial. Okay, now we're getting into the big ones. This has kind of been the year of the IQA cases from the state Supreme Court. And ultimately kind of what they've been saying is, department, you've not really been doing enough on IQA cases. So they've been making a lot of rulings that are changing the way that the department is doing things. So the first one we're going to talk about here is ZJG. And ultimately the holding in that case is that a trial court has reason to know that a child is an Indian child when a participant in the proceeding indicates that a child has tribal heritage. Any indication of tribal heritage is sufficient to satisfy the standard. So the reason to know standard covers situations where tribal membership is in question, but it's a possibility. Ultimately, final determination of whether a child is an Indian child must be done by the tribe itself after it's been formally notified of the proceedings. So anytime anyone indicates that a child may have tribal heritage, the court should be treating the case as an IQA case until the tribe has been notified formally of the proceeding and they make a determination that no, this child is not qualified under IQA. So at any point during the proceeding, if there's an indication that a child has tribal heritage, the child must be treated as an Indian child until the tribes make a determination that the child is not an Indian child. So we ultimately, the tribes are the ones that decide whether a child is an IQA child or not. And until we have information to the contrary, we have to treat a child as such. So in our, for example, our shelter care hearings, the court asks multiple people throughout the shelter care, is there any reason to know that this child is IQA? Sometimes we have relatives there who may have some information if the parents don't. But when anyone gives any indication that yes, we have some ancestry, some Native American ancestry, the court makes a finding that there's reason to know that this may be an Indian child. We try and get the names of the tribes so DCYF can let them know. And then ultimately we have to wait for the tribe to give us notice as to yes or no. Otherwise we proceed as if this is an Indian child moving forward. Okay, other states, also one other note, other states interpret IQA this way, so it's not unprecedented. We were doing it a little bit differently, but this is consistent with some of the other states like Colorado and California. This is also how they interpret IQA. Okay, AMS came out last October. This is a kind of a quick one, but under statute, so this has to do with parents who are doing a psychological evaluation. So there's some immunity that can come from doing a psychological evaluation. So under statute, parents have use immunity from any statements they make in a psychological evaluation for a dependency case. So what they say in that evaluation can't be used for further prosecution of criminal charges. It's obviously information that's helpful for the dependency, but that can't be used specifically for criminal charges. But if a prosecuting attorney, so when this kind of happens, you have to let the prosecutor's office know. If a prosecuting attorney objects to a parent being granted any additional immunity, the court doesn't have authority to grant any additional immunity beyond what's in the statute. So a prosecuting attorney has to be made aware that this is what's going on. And if they object to immunity beyond just the basic immunity in the statute, the court can't do anything else with that. It can't go beyond that. So this is a protection for parents who are participating in a psychological evaluation as part of the dependency case. It gives them some room to talk about some things without fear of being criminally charged in order to help the tailored services for their specific parental deficiencies for the dependency case. Okay, so ALK, this is another tribal case, another IQA case. So parents' refusal to participate in service doesn't relieve DCYF of its obligation to provide active efforts. So no matter what a parent does, if they're engaged or not, DCYF under IQA still has to give active efforts to that parent. The court noted that there is a difference between pre-dependency services, which are voluntary, and post-dependency services, which are court-ordered. Before a finding of dependency, the court can't order a parent to do anything. They have to voluntarily do anything. So if a parent declines to do anything voluntarily, that can't be evidence that the department's engaged in active efforts. So really the court can't consider that because a parent's not ordered to do it, it's voluntary. And so if they choose not to, that's not evidence that the department's done active efforts. They have to continue to do active efforts. Active efforts requires more than just creating a case plan and handing out referrals. The department has to affirmatively assist a parent, and when a parent fails to engage satisfactorily with the caseworker, a caseworker still has to engage the parent. So even if a parent is not doing anything, the department still needs to move forward with active efforts showing that they're doing everything that they can to engage that parent, not just handing out referrals, but additional things, helping with transportation, driving them to things, helping getting resources, phones, things like that. It's got to be more than just referrals and letting them go at it. They have to actually do active efforts. Okay, EM, this is the case that was overturned from Division I Court of Appeals that we didn't really talk about before. So in this case, a private attorney can represent a child in a dependency proceeding without obtaining court approval. So what happened here was there was an issue with placement. Grandma paid for a private attorney to come in and represent the child who was 3 years old. One thing to note is there was no guardian ad litem or advocate on the case, on this particular case. So the attorney puts in what's called a notice of appearance, which basically is a document that says, hey, I represent this child. The court struck down the notice of appearance, and then it went up on appeal. Going back, before we finish this, Tim says, what does active efforts look like? That is a great question. And it's, I don't want to say you kind of know it when you see it, but if you look back at the Supreme Court cases, it's like I said, it's more than just giving out referrals and letting a parent go for it. It's things like helping them, identify treatment providers around them, helping them get transportation to the treatment providers. It's getting, it's helping them make phone calls to the treatment providers. It's a number of things. There are, I think, maybe as part of the IQA Institute, there may be some further discussion about that. I would maybe defer to Ryan. He may have some additional ideas about what some additional, I don't want to say that there's lists, because it's kind of, like I said, you kind of know it when you see it, but the Supreme Court's given us some ideas. Ryan?
I was just going to say, so on this Wednesday at, looking at my schedule, 2:30, we have the reason to know. We'll also be discussing active efforts in that as well. And Laura Lee Bentel is the one leading that. And then next Wednesday at 2:30, as part of the IQA Institute, I would highly encourage you to check in with Commissioner Ressa's session on that Wednesday, where she too will be talking about reason to know and active effort standards.
Awesome. Thanks, Ryan. Are active efforts required before the tribe confirms the child is an Indian child? Yes. If we have any reason to know, if anyone suggests, hey, I think grandma said she had some Cherokee ancestry at one point, then we are treating that child as IQA unless and until the tribe says no. So, I mean, really, so you would automatically be treating, if anyone brings up anything about Native ancestry, you're treating that child as IQA until the tribe has formal notice. They do their investigation, because ultimately the tribe is the one that's going to determine if it's an Indian child or not. We can't do that for them. They have to do that themselves based on their own standards. And that's part of their sovereignty and what they get to do. So until they tell us no, we need to treat that child as an Indian child. And at that point, they may look at it and they may say, yes, this is an Indian child. And then great, that's how we've been treating it the whole time. We'll just continue treating it that way. So yes, active efforts, if there's reason to know that the child is an Indian child, you have to do active efforts until the tribe determines no. Okay, going back to EM. So again, we've got a private attorney who's put in a notice of appearance for this 3-year-old. There's no GAL or advocate on the case. The court said, no, you can't do this. The trial court did. The Supreme Court said, no, hang on, there are circumstances where this is okay. So in certain cases, a private attorney can represent a child in a dependency proceeding without first obtaining court approval. And so an attorney is not required to seek appointment from the court when either the child has the capacity to consent to the attorney-client relationship. This would be older children, or the representation is impliedly authorized under the RPCs, which are the rules of professional conduct. And in order for that prong to be met, it's got to be those 4 things that are listed below have to be in play. So the child's health, safety, or financial interest is at risk. The child is unable to establish a client-lawyer relationship. The attorney must believe that the person has no other lawyer, agent, or other representation. And the attorney must take legal action only to the extent reasonably necessary to maintain status quo or otherwise avoid imminent and irreparable harm. So in this case, you have to have all four of those things in order for a private attorney to be involved in the case without being appointed by the court. So in this case, what really seemed to matter was that there was no guardian ad litem or volunteer advocate on the case. And if you look at that third one there, it says the attorney must believe that the person has no other lawyer, agent, or other representation. And so had there been a guardian ad litem or advocate, we would have been the other representation, and those factors probably wouldn't have applied, and so the representation probably would not have been allowed. The person would have had to go through the process of being appointed by the court rather than just putting in their notice of appearance, being hired by grandma. So I think that case specifically turned on the fact that there was not a guardian ad litem or an attorney on that case. So again, it is possible. The court had some hesitation about this because dependency is a very, very specific area of law, and they really want attorneys who are well-versed and trained in dependency. They just don't want, any old attorney to come in and kind of be involved in a case. So the court was kind of hesitant about it, but they said in very specific circumstances, this is okay. But again, it has to be these very specific circumstances. I want to go back real quick. I see we have another question. It says, do we have to know which tribe the child is related to? No. So a lot of times, at least in our court, I attend all of the shelter care hearings, and we'll have someone who will say, hey, I think I have some Native ancestry. We'll ask, we'll try and find out if they know what tribe. Sometimes they have a name, sometimes they don't. But if we have that information, then a lot of times the department will follow up with family and ask family if they've got some more specific information. We really do need, ultimately, we need some names because we have to send out notice. Well, we don't have, the department has to send out notice to those tribes to allow them to make a determination. So we really ultimately do need a name, but right at the beginning, if we have any idea about Indian ancestry, we have to treat the child as ICWA and do active efforts. The other thing that sometimes gets complicated is ICWA is only for federally recognized tribes. And so occasionally we will have some more regional tribes that are not federally recognized, or we'll have some First Nations tribes out of Canada. And sometimes people understand the difference or know the difference, and sometimes they don't. But again, if there's any indication that there is, we have to do active efforts and treat it as an Indian Child Welfare Act case, unless and until we get some confirmation from the tribes that it's not, which may be not until 2 years down the road. But then at least we have done active. It's better to have done active efforts and then find out maybe this child wasn't ICWA than to have not done active efforts and then find out that they were ICWA and then we've not done what we needed to do under the statute. Okay, termination and parental rights to MASC. So where the department, so what happened in this case was there were some initial contacts with mom. There were some concerns about some of her cognitive skills. She had previously been involved in CPS in Oregon, and they had noticed some concerns about her potentially some developmental delays. So the department provided her service letters, and she progressed with some services, but not others. And so ultimately the court terminated her rights. So where Department of Children, Youth, and Families has reason to believe that a parent may have an intellectual disability, it must make reasonable efforts to ascertain whether the parent does in fact have a disability, and if so, how that disability could interfere with a parent's capacity to understand DCYF's offer of services. So the other noteworthy thing is the Supreme Court seems to indicate that an assessment of intellectual disabilities by a professional is required. It can't just be the social worker's assessment from working with the parents. So they'll obviously be working with the parents, and if they have an indication that there is some sort of intellectual disability, they should be referring that parent for an assessment by a professional so we can get some information to tailor services specifically for that parent and their needs. So DCYF has to tailor its offer of services in accordance with the current professional guidelines to ensure that the offer is reasonably understood to this parent. So that's why we need a specific assessment for this parent so we can offer services specifically for this parent. The department has to prove that it understandably offered the services. So it's not, the parent doesn't have to prove that they didn't understand what they were being told. DCYF has to demonstrate that they provided the information to the parent in a way that the parent understood and could follow up in working on those services specifically. I see a couple of other IQA questions in there. So confirming no IQA action needed if tribe is not a federally recognized tribe. IQA is for federally recognized tribes only. That being said, sometimes there's some confusion about what tribe specifically a parent is involved with or associated with, affiliated with. So there should still be an investigation to make sure that we understand exactly what tribe they believe they're affiliated with. There probably should still be some contact with that tribe, but ultimately the active efforts and the IQA is for federally recognized tribes only. I believe there's 514 or 580 something. You can find a list through the Bureau of Indian Affairs that has the list of the actual tribes. Okay. Couple more here. This one is a big one. Dependency of GJA. This is another IQA case that came out in June. So a little bit of history on this one. So mom and 5 children, the Blackfeet affiliated, so they're IQA for the purposes of dependency. Mom and the kids were in the Tri-Cities, but the social worker was in Spokane. So the termination was filed, and between when the termination was filed and about 5 months later, DCYF was really slow to issue some referrals, specifically for therapeutic visitation. Turns out then the provider that they referred for the therapeutic visitation was not actually qualified to do therapeutic visitation and also didn't have experience working with Native families. There was also a parenting assessment that may or may not have been referred, and if it was referred, it wasn't to a person who had experience with Native families. Mom says the social worker never contacted her. Social worker says mom never contacted her. Lots and lots of back and forth. So ultimately, the court found that the department failed active efforts. And specifically, they were looking at a period between January and June of 2019. So the trial court also speculated that if DCYF had done more, if they had actually done more active efforts, they thought that mom wouldn't have been responsive. And the court said that was not correct for the trial court to infer that. IQA requires the department to demonstrate that it was doing active efforts and that its efforts were not successful before it can actually be relieved of the duty to do active efforts. So you can't speculate. They actually have to demonstrate this is the active efforts we did. This is what was unsuccessful to be relieved of that duty to provide that. So active efforts have to be thorough, timely, consistent, and culturally appropriate. So there's an example, Tim, that may pop up in the active efforts. But again, in this case, a couple of the referrals that were done were to providers who didn't have experience working with Native families. So that may be an issue of active efforts, is finding a therapeutic visitation provider who understands more about the tribal family and the tribal interactions. That may be indicative of active efforts. Tribal resources are limited. So if a tribe is not responsive or not involved in a dependency, that doesn't relieve DCYF of its obligations to do active efforts. The DCYF still has to do active efforts regardless of what the tribe is doing. So IQA and the Washington Indian Child Welfare Act require meaningful active engagement with a Native family. But the nature of the department's actions will vary from case to case. So active efforts will look a little bit different from case to case, depending on the needs of the family and what specifically the department is doing for them. All right, we have one more case and then we'll have time to answer any last minute questions. This one is easy enough. Of course, I say that and something's gonna blow up next year for it, but INRI KD. So there was some confusion. All of the courts of appeals, so Division I, Division II, and Division III, when they were getting a case on appeal, they were naming it different things. And there was some question about what's the right way to name these appeal cases. So the Supreme Court stepped in because they were all doing it differently. Supreme Court said dependency cases should be titled "In the Matter of the Welfare of KD." The child's name should be initials. The child's birth date should be removed. This is out of privacy of the parties. And the parent should not be named either by initials or in the case or by full name in the case title. So ultimately, Division 3 was doing it correctly. The Supreme Court said we will do it as Division 3 has been doing it. But so now in the future, all dependency cases should be named the same with this identifying information removed to protect the parties within the case. All right. So there is my email. If you have any questions that we don't get to today, I am more than happy to answer questions for you, but we do have about 15 minutes or so. If there is anything that we need to address.
Morgan, I have a quick question.
Sure.
Not Anthony, it's Christy, by the way, but anyhow. I'm a new CASA, and I'm just curious about the relationship with HB 1219. What would be the relationship between the CASA and the attorney for a very young child, like you know, a 1 or 2 year old or an infant?
Yeah, so like I said, shameless plug, me and Bailey Zedek are speaking next Wednesday about this. But yeah, so right, because typically, you know, we envision a case when we're working with an attorney for a kid, they're advocating for the child's express wishes and we're advocating for the child's best interest. So my example that I always use is if I've got a 5-year-old who wants to live at Disneyland, her attorney is going to advocate for her to live at Disneyland. Our argument is maybe it's not in her best interest to live at Disneyland. So that's the example that I use. So the when an attorney has a nonverbal client, or you know, like it's 7, you know, 7 and younger is kind of, that's the age that the statute's coming in at. It's kind of what, you know, what does their representation look like? So they have to, the attorney is going to have to make an effort to try and kind of ascertain what the kid, you know, what the kid wants to the extent that they can do that. And then their obligation really is to advocate for the child's legal interests. If they have, you know, and we have the situation now, we have attorneys representing legally free kids who are, you know, nonverbal, you know, infants even. And so their job really is to advocate for what's in the legal interest of a child. So for an example, I have a child, it's a legally free child who is not able to articulate what he wants to his attorney. And so there's this question of whether, you know, what is his permanent plan going to look like? Is it going to be adoption, or is it going to be some sort of long-term foster care based on his situation, or what exactly, guardianship, or what exactly? And so his attorney is going to be advocating for his legal right to be adopted, because that's his legal right. We necessarily don't know if adoption is in his best interest. So that may be where we're, you know, where we're having a different advocacy positions. A lot of times what we are advocating for in the child's best interest is what his or her legal rights are. So a lot of times it is aligned. And then it's, you know, it's just us working with the attorney to provide, you know, well-rounded arguments. You know, a lot of times, you know, it's one thing to have an attorney arguing position. In some courts, you know, and the court really, really likes the advocate's arguments, and they really, really take a lot of weight in what the advocate says. And so then, you know, it's great because, you know, we're arguing our position. We also have the attorney arguing for the same thing possibly, but just kind of working together and coordinating. And sometimes it's going to be the same thing and sometimes it's not. And that's why, you know, that's why there's a place for both in the system. It's because we're, you know, we're often going to be arguing for different things. I see a question in the chat about in CASA reports. Are you saying we remove the child's name, date of birth, don't use parents' names? No, this is just the court decision I talked about is just on appeal. So your program will direct you about what information you should include in your advocate reports in terms of names, birth dates, parents, parents info, all that kind of stuff. Okay, let me see what we got some other questions in here. So Bonnie says, what's the intersection between child's best interests and child's legal interests? And again, it depends. So like in my case that I was just talking about, you know, the child has a legal interest potentially in being adopted, but we may be advocating that that's not in his best interest. And in this particular case, it has to do with the financial situation. So adoption support, the amount of money that could be received by the placement through adoption support versus the amount of money that they receive as a foster placement. It may not be in his best interest to be adopted because then the family may not have the same financial ability to care for him. So that's an example of where legal interests may not be the same as best interests. And then, again, if he was verbal too, that may add another layer in there of, what does this child expressly want? So it's complicated. It's complicated, but there is a place, and there's times, like I said, there's times where our interest, what we're arguing for is the same as what the child wants. And then there are lots of times where what we think is in the child's best interest is not what the child wants. And what's great is the child's attorney has to advocate either for the child's legal interests if they're not verbal or the child's express wishes. We have the ability to collect information and change our position and our argument based on the information that we have. And what we think is in the child's best interest may not always be what other people think isn't. Everyone says, oh, we're working for the child's best interest. Really, that's our position. And there may be some differences of opinion about what is in the child's best interest, but that's what our role is to research, investigate that, and present that information to the court and make recommendations for the court ultimately to decide.
Hi, Morgan. My name's Adrian, and I'm from Asotin County, and I just want to say I greatly appreciated this. It was so nice to be able to have it clearly lined out, the House bills and what's coming down the pike, and also to see all the new case law. So I just wanted to say thank you for a great presentation.
Thank you, Adrian. I appreciate it. And I think I didn't give Ryan my PowerPoint before, but I suppose I could send it. Ryan, are you distributing them or should I drop it in the chat?
Why don't you send it to me? I'm still trying to figure out what the best way to do that is. So it'll probably be on a website somewhere. So
perfect. I will put in a couple of plugs. If you want to stay up to date on what's going on with legislative stuff or with case law, things like that, two ways to do that. One, Ryan does put together, when the legislative session starts, he puts together some information for the program managers. So if you want information about that, talk to your program manager. They can get you set up so you're on the list or can come to the meetings. And Ryan gives us updates on what bills are going on, who are we talking to, where's the funding, all that kind of stuff. So that happens when the legislative session starts in January. So talk to your program coordinators about that and they can get you on that list. The other thing is the Washington State Courts does put out you can sign up for basically a list. And so every time the courts of appeal or the Supreme Courts issue a decision, you get an email and it has a link to it and it tells you about the case. You can't specifically sort by dependency cases. So you'll be getting emails for all the criminal stuff, all the, property law, easement cases. But anytime you see initials, like the last case, anytime you see a case that's titled the welfare of KD, that's a dependency case. And so you'll get an email every time the Supreme Court or the courts of appeal issue a new decision. So that way you can stay up to date on what's going on. So that's all available if you go to the court's website, which is courts.wa.gov. You can see on the right side of the screen, there's some links there that talk about RSS feeds and stuff like that. And then you can sign up for emails. And so you'll get notifications when new cases come out, if that's something that you're particularly interested in.
Hi, my name's Alice Derry, and I did leave a question in the chat. Maybe I had to step out for a minute, and that was this issue of how the social workers have to be actively involved with getting the parents to the services, phone calls, transportation, and all that, versus the reality of our system, which is that the social workers are just incredibly overworked and have too many cases and et cetera, because actually this is very pertinent to the case I'm doing right now. So that's why I'm interested in your answer.
Yeah, It's hard. I'm not sure what the answer is. But what I can say is, ultimately the Supreme Court, our state Supreme Court has said, department, you need to figure out a way to do this. Ultimately, and that's the couple of decisions that have come down is the Supreme Court has said, this has not done, you need to do better. And so go ahead, Ryan.
Well, in partial response to that too, part of what the department is asking for the state legislature, they're asking for, they're called decision packages, but they're asking for increased funds specifically to provide active efforts. So one way that they're doing this, they're asking for a lot of money, basically. They want to treat an active and IQA case as 1.8. So basically almost twice as much work as a reasonable efforts case. So there's that aspect of it. And they are fully anticipating that in Washington state, probably because of this case law that just came out, 25 to 30% of all new cases will involve this active effort standard. So they're actively putting forward and saying, okay, we've got to do this. We need more resources, state legislature. So that's one of the couple of the things that they're asking for in this upcoming legislative session in terms of
Thank
resources.
you so much. Yeah, thank you both. Thank you.
Yeah, so it's really the Supreme Court has been saying, you need to do more, and then finding the resources to treat them, to give the department the resources to be able to do what the court's asking of them. And I just put in the chat, I put in the link to sign up for emails from the Courts of Appeal, if that's something that interests you. So you can go to that link, you can check what boxes, what Supreme Court and Court of Appeal documents you want, and then throw your email in there. And then, like I said, you'll get a notification every time the court issues the new opinion. All right, I don't think I have anything else. So I'd like to thank you guys. I appreciate you all being here. I know this is not the most riveting topic that we have, but please go to any of the other sessions. Ryan's got some great speakers and great stuff lined up. This is a great opportunity for you to collect a lot of information. So I'm happy that I was able to be a part of it. I hope you all have a good rest of your afternoon.